Hi everyone, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and welcome to Last Week Tonight, where we answer your questions and we talk about your comments. So today's Thursday, and what I want to do is I want to go through the comments for the last week and analyze them and answer them. And that's why we call it Last Week Tonight. But only one person in the last 5 years had a problem with it, because there's another Last Week Tonight out there with someone else who's less famous than me, but he tries, and you got to give him his props. I think his name might be Oliver or something. It doesn't matter. But in helping this one person who had a problem with the name, maybe we can change the name. So maybe we'll do a YouTube poll. And I had two ideas. One was maybe comment counsel, because I'm counsel, and these are your comments. So what do you think about comment counsel? And the other idea was a little bit more eclectic, and it's actually Arcadian rhythms. Like you have your circadian rhythm, and that's how you sleep, whether you wake up at 6 a.m. or 8 a.m. And this one was my name, Arcadian rhythms. Doesn't really have to do with law, but I don't know, it just sounds kind of cool, like a little music vibe. So let me know what you think. Arcadian rhythms or comment counsel, or maybe you have a third choice or a fourth choice. Just drop that in the comment and maybe we'll pick yours. And if we do, we'll have to give you something for that. So, yeah. So anyway, it doesn't matter. But let's get into the questions. So the first question is from E.S. Sadia Ben. And he says, hey, Mr. Frekhtman, could a plaintiff lawyer send a demand letter after discovery phase is over? Thanks. Yes, absolutely. The answer is yes. You could send a settlement opportunity letter at any point. I don't like calling it a demand just for the purpose of the whole idea, right, of you making a demand is like you're demanding that they, meaning the defense lawyer, the insurance company, the defendants you're suing, you're like demanding that they do something, right, that they pay you fair money. And demanding is almost like akin to begging. And I don't want to be a beggar. What I want to do is say, look, this is a life-changing forever injury. Your negligence did this to my client. So now pay the equal trade dollar value of what you took away, right? They took something away from my client. So those are all the harms and losses. So now pay me an equal trade dollar value for what your negligence took away to make my client whole, which is to put him or her back to the same place they were before this even happened, which they cannot do with health, right? They can't give you your health back, whether it's a traumatic brain injury, a spinal fusion, whatever the injury is, open reduction, internal fixation. They cannot give you your health back, but at least they could give you money equal to, put you back as much as possible to where you were before. So I like to call it a settlement opportunity letter. But to answer your question, you could do it at any time. You could do it before you file a lawsuit, during the lawsuit. You could settle cases during trial. I've settled cases after the trial was over, while the jury was deliberating, and the judge is like, well, why don't we still talk turkey? And we settled the case for like 1.5 million before the jury came back with the liability verdict. So at any time. Okay, and then Sean asks, hey, Arkady, what's the chance of the insurance company accepting policy limits claim on the first demand? My losses with medical are well over the policy limit, and the defendant is 110% at fault. Yeah, so basically, to answer your question, if you present the evidence in a powerful way and you show them that you're a real trial attorney, or your lawyer is a real trial attorney with a proven track record, like for example, they do a verdict search on your lawyer and they see, hey, they have $1 million verdict, they have a $3 million verdict, then you can go in there, guns blazing, and say, pay me the policy, which is known as a tender, whatever the policy is, whether it's 100, whether it's 500. If your injuries are, your medical costs and your injuries are way above whatever limits they have, you just ask them to tender. And you don't have to keep going back and forth. Going back and forth, like the multiple time thing, like the first offer, the second offer, that's all back to like the old school way, right? That's the way most lawyers negotiate, where they say, oh, we have $1 million policy, what's your demand? And if you say 950, they're gonna say, are you crazy? 950,000? Well, we don't look at the case like that. All we have is 10,000. Why don't you make your demand less? And see, essentially what they're doing is they're like dragging you down into the dungeon, and now you're gonna demand like 300, and hoping that they'll give you something against the 300. But guess what you just did? You just gave them a gift of $700,000, because once you demand 300, there's no way you can go back up. That's just a known thing in that old school negotiating methodology. You can never go back up. You can only go down. So they want to drag you down. I don't play the game. I just say, look, I evaluate the case. I don't give crazy numbers, right? If the case is worth $1 million, I'm not going to say it's worth 10. But like if the case is worth, in my opinion and in my client's opinion, I look into, of course, what my client wants, what I think it's worth, and then I do verdict searches on similar cases, so I have objective evidence of other cases like precedents, and then I say, for example, pay me $1 million, you have until, I usually give them 30 days, so if today's, what's today? Today's May 22nd, right? So I'll say June 22nd at 5 p.m. If you want, pay me, with $1 million by then. If not, it's fine. But guess what? June 22nd at 5:01, it's not going to be $1 million anymore. It's going to be 2, or whatever we agree. And that's how we do it. So yeah, to answer your question though, you could do that. You can get a tender if your your medical bills are over the limit, of course. Because remember, you're entitled to many different categories. One of the categories is past and future medical expenses. Another category is lost wages. Another category is past pain and suffering, loss of enjoyment of life. Another category is future pain and suffering, loss of enjoyment of life. So just give a reasonable amount for each category, but then guess what? Add them all up. And when you add them all up, it's a big number. So that's all you need to do. It's pretty straightforward. Okay, let's go to the next question. It's from Champton, and he or she says, hello, Arkady. You referenced a trial attorney from Las Vegas. Is it possible to provide a contact information for that firm? Yeah, absolutely. But the only thing with that is just text me. It's 347-566-9595. Text me and I'll give it to you. I'll chat with you about your case. I'll give you a free confidential consultation. If you have an attorney, I could even run a verdict search. And so right? Because you're the client. You should be knowledgeable. You should know. You have an attorney, Joe Blow. Has Joe Blow ever tried a case? Does Joe Blow know where the courthouse is, right? Let's run a verdict search. Let's see what are his or her past settlements and what are his or her past jury verdicts. I could do that. I'll send it to you for free, just so you're in the know. I want people to be knowledgeable. That's why some people say I'm the people's champion, because I'm all about the people. I'm not, lawyers make enough money. Listen, lawyers make enough money. You don't have to make any lawyers richer. And you don't want to be the reason there are more or new lawyer jokes. So let's help the people. That's what I'm all about. And then Byron says, what about harassment cases? Yeah, I know some employment lawyers here in New York, and I could probably, locate a good one in other states or other cities as well that handle, I don't know if you mean like employment, like sexual harassment or some other kind of harassment, but just let me know. We handle those cases as well. And then H2 of Film Crew says, I'm down here in Florida and I tripped and fell on an open water sewage pipe, PVC. My current lawsuit is in litigation and my deposition is in July. I've had multiple shots on my hip and my shoulder where I fell, along with cuts and bruises in the right foot, which I have pictures of. Do you think I have a decent case? The complex has $1 million policy and my lawyers are asking for $250,000. What my lawyer did say was if it goes to trial, they're gonna ask for substantial. Is that something that's normal? So you're in Florida, you tripped and fell on a sewage pipe. So guys, I guess the sewage pipe should not have been wherever it was. It was an unsafe condition, it was in a walkway, and your lawsuit is in litigation. You have your deposition coming up, and you said multiple shots on the hip and shoulder, along with cuts and bruises. Yeah, I mean, it sounds like a good case. I'd have to look at the medical records to know exactly what the diagnosis is. Like why did they do shots? See, shots on the hip are like the treatment, but what's the injury? Like the key thing is what's the injury? If you have like a torn labrum, you might have shots on the hip, but then later a torn labrum might need a surgery. And then if that doesn't work, you might need a hip replacement. I'd have to know your age. I'd have to know what city in Florida. So it's best to just text me, 347-566-9595. That way I could do a consultation, I could give you more information. Otherwise I'd just be guessing, right? And if one piece of the puzzle, if I'm wrong on one piece of the puzzle, like your age or your diagnosis, then everything else is wrong, right? So that's why I don't like to answer a value from comments. But it sounds like a good case. And if they have a 1 million policy, you should ask for excess umbrella, because it's a big complex. They probably have it. They probably have 1 million with like a 5 million excess. Maybe I saw one case with a 25 million excess, right? And then also, why is your lawyer only asking for $250,000? And if he's not going to get the 250, what does he mean by when I go to trial, it's going to be substantial? He's going to ask for the million, or why doesn't he just do it now? Just send him a letter and say, pay me 250, you have 30 days, right, until June 22nd at 5 p.m. But if you don't, then it's not going to be 250 anymore. It's going to be like 1.5 million. But I wouldn't even do that. I would first find out how much insurance there is and find out what your diagnosis is. And are you going to have any surgery? Are you going to, because if you're not going to do any more treatment, then maybe, 250 is reasonable. But if you are, then it's not reasonable. You know what I mean? So there's all these issues in it. But yeah, I think that you definitely have a good case. And I'll put in here that I answered this. And then Diwali says, hello, what if the insurance company is not responding? I'm handling my own case. It's small, so I do not want to retain a lawyer. Yeah, so I mean, if you're handling it yourself, what you have to do is send them a letter, give them a call, speak to the adjuster, see if they'll offer you some money. But if they don't, then you have to file a lawsuit on your own, which you could probably Google. I helped somebody in Texas do that. You just Google, for example, petition, template or sample petition for a lawsuit in Texas for a personal injury case. And they have them in Google. You could just take it and then change it, make it your own. Same for any state, I think. And then just kind of write it up and file it. You might have to pay a filing fee. Or some states have if you're unable to because of your economic situation, you might have to fill out a declaration and they'll give you a free filing. And then that's about it. And then but then it's hard to do on your own, honestly. It probably is good to hire a lawyer. But if it's really small, you just, usually you call them. If you file a lawsuit, that'll get their attention. They'll probably settle with you at that point if they're not responding to you now. And then Adam says, I'm a gunshot wound victim with multiple surgeries years ago. I was recently hit by a car while on my e-scooter. Will my pre-existing injuries come into play with my injury claim? Yeah, I mean, depending on what the injuries were. So if you have a gunshot victim and you've had multiple surgeries, now, depending on what the injury is from being hit on the car, you were on your e-scooter, you got hit by a car. So what are your injuries from being hit on the car? And has any injury, for example, the surgeries you had years ago from being a gunshot victim, were those injuries from those surgeries, were they made worse by this car crash, right? That's the question, because with pre-existing injuries, see, some people think pre-existing injuries are bad because the defendant will say, well, this is all pre-existing. And that's true to the extent that you cannot get compensated twice for the same injuries. So if you come into court and say, I have injuries from a gunshot 10 years ago, I want money, and the fact that the car hit me, didn't really change anything, well, then you're going to send you home with nothing, right? Because you've already had all these injuries from the gunshot 10 or 20 years ago. Why are you coming to court and trying to pin those injuries on this car crash, right? That will not work. Don't do that. But in a way, pre-existing injuries could be a protection for you. And what I mean by that is that you come into court and you say, look, you take me as you find me. If I was a perfect specimen, like a bodybuilder goes to work out, and then you hit me with this car, nothing would have happened, and you don't have to pay me very much. But if I'm an octogenarian, I'm 87 years old, I'm walking, I'm frail, I'm vulnerable, and you tap me with that car, I fall over, I have a brain bleed, I need brain surgery, I may die, I might be in a coma, I have these massive injuries, I have massive medical bills, my medical bills are $1 million. Well, you can't say, oh, I should have hit the bodybuilder, I should not have hit the 87-year-old, right? It doesn't work like that. They take their victim as they find him or her, right? The victim could be frail, the victim could be in great shape. It doesn't matter. So they can't harm people, basically. So the fact that you have this pre-existing condition with these multiple surgeries is a protection for you, because if those injuries, let's say you had a gunshot and you had a major surgery to your leg, for example, and now that leg injury has been made worse by the car crash and you need another surgery, but it's not because of the gunshot, it's because of the car crash. So that's why it's called an aggravation. You're aggravating what you already have. Exacerbation, you're exacerbating the condition that you already had. And you can recover money to the extent it was made worse. So that's what you have to do. Cherium says, my question is, how much is a slip and fall for an uneven sidewalk with a fracture to the right ankle and also damage to the midfoot? I had 2 surgeries on the ankle and then on the midfoot with screws put in. My problem is when I did the deposition, I told him I had to have a second surgery because I felt like it would have been too much swelling, probably. I am a diabetic. Now, all of a sudden, my lawyer doesn't want to add the second surgery, even though this was in my MRI. He is trying to get them to settle. I don't know what I should be settling for. Right, so I mean, I can't really like advise you on a comment. Just text me. Again, it's 347-566-9595. I'd have to know a little more, like what city you're in, what the actual diagnosis is. I mean, a fracture to the right ankle, and you said damage to the midfoot. You had 2 surgeries for the ankle, but the lawyer doesn't want to add the second surgery? It makes no sense. Of course you have to add the second surgery, as long as the second surgery was from the injury. No, it's traumatic, it's from the slip and fall. Of course you have to add it. Why would you get them to settle without the second surgery? They'd only pay you half the value of the case. It sounds like maybe you don't have a real trial lawyer. I don't know. There could be a lot of different issues. That's what I'm saying. So for me to properly diagnose it, it's better to text me, 347-566-9595. I'll drop it in the comment too. And Kazumi says, I had a car accident on February 25th. I have a fracture on my skull and a small fracture. How much can I get? Well, I mean, look, if you have a fractured skull, it's nothing small about that. What you need to do is go to a neurologist, neuroradiologist, do like traumatic brain injury scans, MRIs, maybe a SPECT scan, functional MRI, could be a diffusion tensor imaging, a DTI, get a full workup. That could be a big case. You have to see how much insurance they have, right? So if it's a car accident, if all they have is like 25,000, well, you're limited by that. But if they have, let's say, $1 million, well, then you can get that. It's basically whatever they have. If it's a skull fracture, usually you could take the whole thing. So, but that, again, just probably better to text me. We could do a consultation. I could give you all the information. And then William says, hello, Arkady. Once a note of issue is filed, what typically happens in Queens? Yeah, so what happens is when you file the note of issue, you're telling the court that all discovery is complete and you're ready for trial. So then the court puts the case on the trial calendar and you're like in a waiting list, kind of like when you're online in a grocery store. And then when your turn comes up, that's when you go to the jury and you have the actual trial. So that's basically what happens. But while you wait, which in Queens could be about a year, so while you wait, you're gonna get settlement conferences, not compliance, but settlement conferences and also pretrial conferences. So things will still be happening. So that's important. I would go to make sure the lawyer goes to those. You could also do a private mediation, things like that. Here's a question from Daniel. He says, in response to the video, legal process continues, no restart. Oh, that's the one where I talked about when you change lawyers, right? Wherever the lawyer is, the first lawyer, wherever the first lawyer is, whether he's right before trial, whether he's in depositions, if you change lawyers, you don't have to go back to the beginning and start over. You just continue from where you are, right? So that's what I meant by that there's no restart. So he says, theoretically, I could just stall the beginnings by falling out, quote, falling out, unquote, with my lawyer all the time. I'm not really sure what that means, because why would you want to stall your own case? I mean, I guess you could, right, fall out with a lawyer, be like, I don't like you, and go to another lawyer and just keep doing it over and over. But what would be the benefit? You would just, then you would be stuck, right? It would be like spinning in one spot and you wouldn't really be moving the case. So what would be the purpose? I don't really follow. Never know when you can use something as leverage, a trick or a loophole. But then you'd be tricking yourself, you know what I mean? Because it's your case, right? You're the plaintiff. What you want to do is get to the finish line as quickly as possible and get your money. But if you keep firing lawyers, I mean, you could, I suppose, but then, first of all, lawyers are not going to keep taking it. Maybe once, twice you could do it. But then like third or fourth, they're gonna say, how many lawyers have you had? The 5 lawyers. They're gonna be like, this guy's a red flag. Why does he have 5 lawyers? No one's gonna take your case, first of all. Second of all, you're just tricking yourself, because then all you're doing is, remember, when you switch lawyers, like the first lawyer has to send a list of his expenses. So the second lawyer has to pay all the expenses. Sometimes the expenses are a lot, like $3,000 or something. I had one case that was like $25,000, it was a big case. It could be a lot of money you have to pay. Second of all, you have to share the legal fee. So if the case settles for $1 million, the client gets $700, right? But then the 2 lawyers have to share the $300. So instead of me getting a fresh case where I get the $300, right, I have to now get $150, for example, and the other lawyer gets $150, so I'm getting less money. But maybe it's not $150. What if I come into the case late, right before trial, and I just settle it? I help settle it. Well, the first lawyer is going to say, but I did all the work, right? I filed the lawsuit, I did depositions, I prepared it for trial, I got the medical care. All you did was make a phone call. So then it's going to be like $275 to him and like $25 to me. So a lot of lawyers are going to be like, why do I even want to set foot into this for $25K and have a headache and have a trial in a week? So it's hard to switch lawyers, but like doing it over and over again, it just makes no sense at all. So I have no idea even what you're saying, but I don't know. Merle says, as the months go on, does the cost go up for lawsuits? I mean, yes, it can get expensive depending on what you're doing. It's not really the time that gets expensive, it's more like what you're doing. If you're hiring experts could be expensive because they might charge like $3,000 for a retainer, they have to go examine a truck. A liability expert might want to go and examine like a defective sidewalk. Engineer, he might charge $3,000, $5,000. Then if you're on for trial, that same expert might say, well now, if it's a doctor, I have to cancel all my patients, all my surgeries. I have to come to court and be in court with you the whole day. Prep, some doctors say just for prep, I want $1,000, and to come to court, I want $10,000 or $20,000. So that's where it gets expensive, usually is trial, but it really depends on what you're doing more than the time. Although the time could also be expensive, of course, but it's more about what you're doing. And Laura says, from what I've been looking at so far, it depends on the injury and insurance. And she's responding also to the video why your case could be worth either $5,000 or $500,000. And that's true, right? You definitely need big insurance if you want to get big money. And yeah, usually the whole idea of personal injury is to compensate you for your injury. So if you have a bigger injury, you get more money. If you have a smaller injury, you get less money. Okay, Dasani Williams says, hi, Mr. Arkady. How much can I get for a torn meniscus and a shoulder surgery, which had a torn in the labrum too? Yeah, so I mean, basically, if you have a torn meniscus in New York, usually I settle those for $150,000, $200,000, in that ballpark. If you have a shoulder surgery with a labrum, now you have double. So let's say torn meniscus in the knee is like $150,000, $200,000. Torn labrum in the shoulder, if both are fixed arthroscopically, now it could be $300,000, $400,000. I've had shoulder cases, with a little bit more involvement, like anchors go for even $850,000. So it's hard to say exactly. And someone says, interesting enough, says, first 20 seconds of the video, he literally says he cannot tell you how much your case is worth, LMAO. Well, no, the idea is I could, if you text me and we do a consultation, I could give you an estimate, but I can't tell you based off a comment. If you say something like, my back hurts, what's my case worth? I don't know where you are. I've done videos before where I talk about the factors that I would need to tell you, which is, your name, where you, I don't need your name to tell you what it's worth, but I mean like if you contact me. So basically your city, what the injury is, what the liability is, what the policy limits are, all those factors, right? The venue, and then what's your human story too, right? Because if you have no human story, if no one ever worked it up, if it's just like my back hurts, I have a L3, L4, I have a C3, C4, the jury's not going to care. They're going to be like, C3, what's that? Is that the guy from Star Wars, C3PO? The whole point is you want to show how it's a life-changing injury for you. That's the human story. That's where the big money comes in, right? So yeah, I mean, like I know everyone wants to know, but you're not going to find out from a comment. You're going to need to do at least a consultation with somebody, and they're going to have to review your file. Ski says, I was hit by another vehicle head-on because a box truck ran the red light going about 40 miles an hour, 40 to 45 actually, in a 25-mile-an-hour residential area and hit them, made them hit me, and Leo, the box truck driver, hit me. It was in the report that the box truck driver was 10K pounds and it had a 1 million coverage, but the box truck driver lied and said, I ran the red light and hit him. Well, I mean, look, you have to prove liability. So you don't have to really, just have the lawyer look at everything, get all depositions, videos if there are any, sometimes black boxes from the trucks, like the electronic data modules, EDR modules, everything, all the evidence, witnesses, and then you prove that the defendant was at fault. And then he also says 22 stitches in the forehead, diagnosed with PTSD, out of work for 6 months, physical therapy, concussions. Yeah, so you have a brain injury, so you got to see how much policy there is. And he's asking if he can get the whole million. Well, no, I mean, don't go for the million. Ask if they have excess umbrella, because they might have $1 million with like a 10 million excess. So get that first, and then when you know the full coverage, so you got to ask them for like any excess, umbrella, concurrent, supplemental, or any other coverage that could be applicable to this loss, meaning this crash, other than the 1 million primary policy you have previously disclosed. Because they've previously told you they have $1 million, but you got to ask them, do you have anything else? And then if they say no, ask them for a broker affidavit and an affidavit of search, that you searched the insurance brokers, everyone searched, and there's nothing else. Get affidavits from everybody. Right now you know there's definitely nothing else. Then you could say, tender the $1 million to me, because I have a PTSD, I have a traumatic brain injury. But if they have 10 million more, then you want to know that, and then you ask for 11 or whatever. Go for the whole thing. It's a good case. I don't see any issues with that. And text me if you have any questions. All right, everyone. Thank you so much. Please like and subscribe to our channel. If you have any questions, just text me, 347-566-9595. Our goal is helping serious injury victims and families. All the best, everyone. And if you have a case, I hope you get full justice. All right, bye-bye.